See
Okay.
you. Awesome. Then we can
Yeah.
start. Welcome to Cornerstone Insights, where we hold conversations for founders building firms that are designed to scale and build to last. I'm Kamala Ravi, your host and founder of Cornerstone Sales Consultings, where we support RIAs, fintech, and RegTech leaders and sales team build structured, repeatable revenue processes for the next growth stage. Today, we're going to tackle a very interesting topic, thanks to my good friend Chuck, a returning guest. Why fintech, RegTech, and RA founders get legal wrong as they scale. And that's something that I don't think we talk enough. And Chuck agrees with, we both agree on this. So as many fintech, RegTech, and RA firms scale, legal often becomes reactive. They're handled by the hour or deal by deal. But high growth regulated businesses don't break because of one bad contract. They can break because legal strategy isn't integrated early enough. And many times founders, and many times they have reasons for saying, we're not ready for a full-time general counsel. But the real question is, what risk are building while you wait? So today we will address where the traditional legal model falls short and how a fractional CLO can change the speed, clarity, and confidence of your decisions. As I mentioned, my great friend and our returning guest is Chuck Christofelis. Chuck, before we start, why don't you tell us a little bit about your company, what you do, and then we'll kick off the questions.
Okay. Thank you so much. Yeah, I just formed Aristo Oversight Solutions, so I act primarily as a fractional general securities principal for broker dealers. I also have a law firm in New York, the law offices of Charles A. Christofelis or Christofelis Law, and I've been in this business, I hate to say, almost 30 years now. And so I've worked for companies where I was the seventh employee. I've worked for, teams where there's just literally a few people, like 0 to 1. And I've worked for some of the largest and most successful financial institutions in the world, including Northern Trust, Merrill Lynch,
Yeah,
Principal Financial Group, and et cetera. Yeah. So I
great
make a living of
experience.
sorts doing this, and I
Yeah.
love doing it. And, it's
And I can attest that you have great experience. And I do apologize, I mispronounced your last name, so I do
no,
apologize
yeah.
for that. So let's dive into. We have a couple of questions lined up. The first question is, why is it that the traditional billable hour legal model breakdown for the startups, for founders of RegTech, FinTech, and RAs? Number one, and tied to that, second question following that, what problems can a fractional CLO actually solve?
Yeah, both great questions. And, more than anything else, I think there's the legal model, the billable hour big law model is broken, right? Because especially if you have a fintech startup, you're needing to get to market. You need to launch and get off the runway. And it's not like there's intentional to slow things down. It's very important to be methodical, to have all the T's crossed and all the I's dotted. But unfortunately, as attorneys were trained to be very methodical and careful, and then that law firm model, the big law billable hour, creates this inherent conflict of interest where you're trained as an attorney to spot issues and bring in subject matter experts on different fields, where you're dealing with an entrepreneur that just wants to launch. And so that's an inherent conflict of interest. So my goal is to create a chief legal officer fractional CLO service, general counsel as a service, where for small companies I can serve as the outside general counsel without the sticker shock of, high hourly rates or 5-6 figure bills that they didn't expect.
Well, and let's focus a little bit on this, because what you just mentioned about being a fractional CLO, because you have identified this issue. Can you elaborate about the benefits and the value that a fractional CLO brings as opposed to a full-time general counsel or outside traditional law firm, which are both wonderful models. They are necessary, but obviously a fractional CLO is a fairly new idea. So why don't you tell us a little bit about that?
Yeah, I think the unique selling proposition is that you can call me and ask me anything. And I've been there, done that. Especially if you're on a very, very small, if you just have a startup with a few people or a half dozen people, it's great if you have some of the biggest law firms in the world and you can talk to the guy who or the girl who wrote the regs and they charge $1,000 an hour and this kind of thing. But it's not so easy when you have an urgent question and you're trying to develop a product or a service, you're trying to launch your platform, and you can't wait 2 weeks to schedule time with the partner at such and such a law firm. Not only that, I think there's a lot of various operational issues that the big law partners, they might understand inside out backwards some of the legal and regulatory areas, but they're not operators. Like, they've not worked in a company where you actually had to launch a fintech platform and
So
wake up in the middle of the night to help people reset passwords or deal with inquiries from law enforcement or
yeah,
regulators, right?
right, right. No, so what I'm hearing is that you are a founder of a startup, or you're moving your RA into a growth pattern, and your legal needs are going to be varied, and you're going to need some quick turnaround time. So maybe if you can pinpoint, having a ask me anything fractional CLO legal partner, how that can enable founders do things faster or better.
Well, both faster and better, right? But I'll start with better, because there's a lot of traps for the unweary. All right. And
Right,
if nothing else, I would tell founders that you don't know what you don't know,
right,
and to start out with a sound foundation
right,
and you don't need the high touch integrated contract management system. Even just understanding what, a non-disclosure agreement is and what it's for and when it's appropriate or not, what to agree to, what not to agree to, basic, contract provisions of, non-compete, non-solicit,
right,
venue, forum, things like this. Even if there's one thing I would tell founders, it's even just getting an Excel spreadsheet and recording what agreements you signed with who, when the expirations are, and what the cost is, right? That's key. Another trap for the unweary, especially in the broker dealer space, broker dealers will launch and say, "Oh, we're going to be in all 50 states." And that is an arduous process. I'd recommend, really just trying to focus on launching in, it's the 80-20 rule, places like New York or Florida or Texas, California, rather than trying to do all 50 states at once. And certain states, Massachusetts is in particular, has their own standards for broker dealers, fiduciary standard, for
yeah,
example. So I guess just to sum it up, as a founder, especially in the fintech space, you don't know what you don't know. And you can go to a law firm and they can, you think everything's perfect, and then you're dealing with Illinois Secretary of State or Massachusetts Securities Division on intricate and nuanced requirements that they may have for your broker dealer.
right. Thank you for that, because you really
Yeah.
touched already on when a founder says, I don't need a full-time general counsel, yet you already outlined some of the examples what the legal risks are, and those are usually underestimated. Which brings me to a question, if you can share. Can you walk us through a situation where a business decision looked commercially attractive, which everybody loves, but legally created predictable downstream risk?
Yeah, I can think of many examples like that. I think the money transmitter, and the money transmitter side, a good example is everyone says, okay, we're going to become a money transmitter, or we're going to avoid being a money transmitter, or we're going to structure it
Right.
in a certain way. And this is extremely dangerous these days with the AI, right? You get
Yeah.
like half-baked information. So I think it's more than anything else, you need that clarity, and you need to have a laser-like focused on your minimum viable product or service,
Right.
and visualize the strategic intent of where you want this to be, right? And people always think that they have there's nothing new under the sun, and the laws and the rules that we're dealing with are like literally 100 years old. A lot of them started out the 33
Mm-hmm.
Act, the 34 Act, the
Mm-hmm.
40s Act. Even the money transmitter laws and rules go back to like the 1970s and 80s. So yeah, it's easy to think that okay, we're going to do this, and I'll give you another example. I'm sorry, kind of
Mm-hmm.
rambling here,
No, no,
but
it's good.
oftentimes they'll see what they think is a good opportunity. For example, people getting into the space will say, "Aha, we're going to offer our service to pension funds because that's very easy." Pension funds are these big pools of assets, and they're being underserved. And when you get involved in that, each state is different. For example, New York, you have to register as a lobbyist to even pitch a pension fund. And again, it's put this in the category of no good deed ever goes unpunished, right? So founders don't know what they don't know, and I've seen it time and time again that great idea, but they just try to, it's the concept of throwing up spaghetti against the wall and see what sticks.
Yeah.
And it's not such a great strategy because this is a very humbling role. I've been doing this almost 30 years, and every week I learn something new. There's some nuance, some unwritten, regulatory interpretation that only the village elder at a certain regulator knows of. And you just have to, have time and experience in the space to navigate that.
Right, right. And that brings me to another question, a couple more questions, but one that pops that I think is important, ties to what you just said. What types of small, quote unquote, legal decisions tend to compound into the largest problems later? What have you seen in your experience from a
Yeah,
founder's perspective?
no, great question. And it's, just to think that we can just do this one thing on the side. Again, it's the lack of clarity or focus.
Well,
And, for example, hey, let's offer our own, token. Let's offer our own utility token.
yeah,
Let's do an NFT platform, right? Or whatever it is, right? Let's offer a bill pay service. And if you don't know what the potential consequences are, it's easy to think that, oh, this is all accretive. We can just offer this additional service and it makes sense. But it's not as simple as just adding something to the menu if you're a restaurant, right? In financial services, it's a whole different ballgame. So, for example, if you're offering um, an asset-based management service, you just cross the line to being an investment advisor. If you're an
yes,
advisor and you do one-off transactions and you're charging, commission based, so it's not
yeah,
as intuitive as you might think.
right, right,
And the other thing is that the and don't take this not directed at you, but the business development people will have a great prospect or a great lead, like, hey, we have this great opportunity to do a transaction, supporting this company doing import export business out of Colombia or something like that, right? And it's not as simple as you think. Like that sounds
yeah,
great,
yeah,
and it could be seemingly innocuous. Oh no, they're importing flowers from Colombia, right?
yes.
But you know,
Well,
yeah,
and that's the reason why, my sales consulting services for RIAs, they compliance has to be my partner since day one, since the first conversation, and nothing gets delivered until compliance approves it. So there is that cooperation, which you and I touched on in our first video recording a couple of months ago.
mhm.
Anything else you would like to add on this particular subject that you just addressed?
Yeah, I'll just throw this out there also that people think this is one of those cases where, like to give you an analogy, like, cats have four legs, but not everything with four legs is a cat kind of thing.
Uh-huh.
People think that if, okay, we're just going to operate our business ethically and, make good decisions. So it is true, that gets you a lot of the way there. I won't say it doesn't, but technical requirements with the rules is how a lot of regulators through fees and fines generate revenue. All
Mhm.
right. So it's not, you can't just be a good person and say like, hey, and I've heard this so many times, more times than I can count on all my fingers and all my toes. Like, hey, we're good business people, we're ethical business people, we're operating our business in a very ethical manner. And as far as the regulators are concerned, that's meaningless, right? If you had to file a form, if you have a disclosure with wording that's not absolutely perfect, a lot of times, unfortunately, the regulators will use that as a revenue generating opportunity. I will also say, conversely, that if you have nefarious intent, all right,
Mhm.
there's no level, and certain business people have, very, very aggressive, I'll put it that way, right? And could not care less about investor protection and market integrity. And there's no level of lawyering up or compliance or legal that they can get that will help them in the long term. Eventually, that catches up with you.
Right. So,
Yeah.
I'm gonna just shift a little bit because I want to touch on something that RIAs know about this. I do believe that 99% of RIAs in general, they take fiduciary responsibility very, very seriously. They do the best
Okay.
for the clients. They're not out there to be malicious and run away with clients' money. You have those situations, but fintech, there and I would say to a certain extent RegTech, but fintech in general, because they have such, and crypto asset manager, they have such esoteric new type of investments. I How do you think, or what do you think about the difference between what is technically legal and what is strategically or ethically sound for a regulated firm versus, well, you're getting close to doing something illegal or ethically wrong, and you will pay the price. What is that fine line that the founders need to kind of pay attention to?
Right. Well, yeah. I mean, it is a fine line, and I think you have to start with the premise of, again, investor protection. You can never underestimate how unsophisticated a lot of investors are.
Yeah.
Unfortunately, and you're going to know what I'm saying, this is probably going to resonate with you and a lot of people watching this. A lot of people think, oh, the FINRA rules are very complicated, and let's just become an advisor, not understanding that it's a much higher duty of care. All
Yes.
right. If
Yes.
you're an investment advisor, you have a fiduciary. Now, don't get me wrong, in Massachusetts, all right, they have their own regulation. They don't follow Reg BI on the broker dealer side, and you have a
Right.
fiduciary duty of care, even if you're a broker dealer in Massachusetts.
Right.
But for all practical purposes, less regulation or a different type of registration or regulation doesn't mean it's seemingly easier, but it's much more stringent.
Right.
And yeah, and investment advisors in particular, right? It's not just it's so there's a big difference between rule-based regulation and principle-based regulation. Of course, the
Right.
Investment Advisors Act, there are rules under the Investment Advisors Act. However, it's more of a principle-based. They don't have a
Hmm.
thick rule book like FINRA,
Right.
but at the end of the day, the regulators and the Securities and Exchange Commission have a great deal of leeway to say, hey, was this advisor putting the client's interest first?
Yeah.
Or did they have an attitude of I got mine and never give a sucker a break kind of thing, you
Right.
know?
Right. Right.
And unfortunately, you see like very aggressive, I'll use that term, operators thinking, oh, we'll just register as an advisor and avoid FINRA. And that's not how it works.
Right. Right. So, I think now we're moving into the arena where founders may have to make some tough decisions. And I think a lot of those decisions may be driven potentially by misconception. So under the ages of what misconceptions do founders have about asking quick legal questions, and how that actually drives cost? Because there is, tied to that, there is a resistance about spending, the legal spend, and when they're working with the reputable firms versus hiring a fractional CLO, for example. So they're all tied together. Can you provide some thoughts on how to help founders manage that balance?
Yeah, I think, well, first of all, and I don't mean to say anything to disparage my colleagues, but lawyers are very, usually very nice people, very smart, very knowledgeable about the space. So it's just easy to talk to lawyers. And I think a lot of founders have the experience where they're just on their phone with the lawyer every day, asking this question and that until they get, sticker shock with a
Yes.
huge bill that never
Yeah.
gets paid. So I think it's important, to set expectations very clearly. And I think, again, my colleagues just get very excited, as I do, for startups. And you have to understand exactly what the relationship is and how you're going to be billed with any law firm and when you're going to be billed and when you're expected to pay. And I think a recurring thing in the startup industry is an inordinate amount of legal fees go unpaid. All
Yeah.
right. And law firms are starting to get better at this, or saying, okay, here's our, the first 20 grand's on us, or the first, incubator type thing, that here's everything you need to do, and here's some YouTube videos. So the big law firms are getting much, much better at that. But it's not like most other services. There is kind of a lack of transparency in terms of how you're billed for legal services, when you're billed, and lawyers are notorious for sending a bill. And I've seen this on the other side of the fence as general counsel of companies. Sometimes it would be months or even a year later. I'd get a bill from a law firm. Oh yeah, this is from last year. We spent all this time on your issue, and here's the invoice you know so it's very important to have not only clarity and focus and good corporate hygiene, but to have clarity on your legal spend and how you're spending it, and ask for fixed fees whenever you can, whenever it's reasonable, and have control over that.
So this is great advice. Obviously, have a budget for legal expenses, whether for outside counsel or fractional CLO or in-house general counsel. Along the same lines, the next question that pops in my head is, when should founders and how should founders evaluate whether they need a fractional CLO when it's time to hire an in-house general counsel, and whether their current legal setup matches the complexities of their business model, which will constantly evolve, obviously, as you grow.
Mhm. Yeah, I think it's a great question, and I think it's just call out and different law firms, whether you're talking to me as a fractional CLO
Right.
or the big law firm you're working with. Just say like, hey, what's the reasonable amount of spend? I think what happens oftentimes is entrepreneurs kind of get ahead of their skis and will branch into different markets in different countries and different
Yeah.
products or services, and then they're dealing with things that, again, that you have to set a very sound foundation. So I
Yeah.
don't think it hurts to ask. And again, when you're talking to any, whether it's a small, medium, or large law firm, or CLO as a service like I'm offering, just ask like, hey, what's reasonable? The regulators, I think, have a rule of thumb that you should have X number of people. There are very specific statutory requirements. For example, for broker dealers, you have to have two general securities principals. You have to have a financial operations principal. There is no hard requirement for how many lawyers or law firms or you have to have. But I think as a rule of thumb, that should be a significant part of your business to be
Right. Right.
cautious. Yeah.
No, makes a lot of sense. And one last question: if there is, or can you think of one legal mistake that you could wish and you could tell founders that they really need to avoid as early as possible or earlier in their business? What would it be and why?
Oh, wow. Just don't sign everything that, there's this tendency just to launch, right? And
Yeah.
we have to get going. And just there's nothing that can't wait a day or two, 72 hours, right? And read the agreements you have. Think about the agreements you're entering into. Those are covenants. It's very important, right? And catalog those. And if someone sends you an agreement, and unfortunately in this day and age, I'm dealing with this, everyone in the industry is, that there's, these terms of service that
Yes.
are dozens or of pages that said, hey, we're gonna
Yeah.
change this anytime we want, and if you continue to use our platform, you agree to it, right?
Yeah.
But I think it's very important to read and understand, and if you don't understand, ask,
Yes.
right? And the other thing is, and this would save people a lot of money, a lot of time and money, is just simply create an Excel spreadsheet, create a Microsoft Word document, and just record what agreements you enter into, when you entered into it, who you entered into it with, the, cost, and whether it auto renews or not, this kind of thing. Because both from a financial standpoint, well, not just financial, operational, and legal, you need to understand what agreements you have where, what they cover. And fintech startups in particular that I've seen are notorious. Every shiny object, every new app, they'll just go
Yes.
and click and sign up for it. And then all of a sudden you have, these monthly expenses that are just off the charts
Yep.
for apps
Yep.
people aren't even using.
Yeah. And that's why then there are companies that actually have technology software or apps so they can keep track of all those expenses and contracts, which is a whole separate story. Well, Chuck, if people want to reach out to you, why don't you let us know how they can reach out to you?
Yeah, well, I'll give you my website. You can add a link to that, and or just pick up the phone and call me. My number is 925-787-8593. My law firm is charles@christofelis.law. It's pretty easy.